a big difference. And if you can have this laundry list there and you're organized about going after it, to me, I found it very helpful. And just, I want to say one thing here about inconsistent statements and impeachment. You know, I see a lot of people that in the audience that I wouldn't dare lecture to about preparation or anything else in the law. And I know there's many, many experienced lawyers out here. And yet, I would surmise that probably amongst, the 100 of you that are here, a good half either don't know how to impeach a witness or are not that confident in how to go about impeaching a witness. And I would tell you that in almost every trial, when you're going about impeaching a witness, somebody is not going to know what the fuck is going on. Either the prosecutor's not going to know, or the judge is not going to know, or you're not going to know, right? And you're going to get objections all the time, even when they're totally wrong, and they're going to get sustained all the time, even when you're totally wrong, right? And you have just got to be bullheaded about it. And if the judge keeps sustaining the prosecutor's improper impeachment objection, over and over and over, then ask to approach and have whatever the judge's, wrong understanding of proper impeachment explained to you by them, right? So that you can go through it and actually get all of these statements out. This is enormously important to get the inconsistencies out there, and do not be afraid simply because a judge is telling you you're an idiot, or because a prosecutor is objecting that you're not doing it correctly. Just press on with it. And if you have any questions about it, this is not something that anybody, certainly a trained lawyer, likes to admit. And if, feel no shame, come find me in the courthouse. I'm happy to go through it with you individually, but 613 is the statute. You've got to make sure the witness knows what the contents of the statement are. You've got to make sure that they've been told the time and place of it. You've got to make sure that they know who they said it to. And you've got to give them a chance to acknowledge it. And if they don't categorically acknowledge it, then you are allowed to impeach them with whatever they said before. If they waffle on whether they said it, if they're not sure, you still get to impeach them. So, as I said, the rope versus wire issue turned out to be a meaningful pleading issue. The other thing that turned out to be meaningful, and I didn't really anticipate this, was the DNA. And, this woman knew the guy, right? So, in a way, the DNA shouldn't have mattered, because, why is she going to pick him out? And, she knows him. She doesn't have any reason to lie about him. But for grins, I filed a Daubert motion just to challenge the CODIS. And, my experience with CODIS is that it's always right. I haven't ever seen CODIS wrongly identify a person in one of my cases. But I filed the Daubert motion anyway, as much as anything because I was trying to screw with the state. I just wanted to see them put through their paces. But additionally, I wanted to create a confrontation issue for appeal, because they wanted to just put on their final analyst and not have any of the other analysts that were involved in the DNA testing have to testify. And as I filed it, it turned out that there were a whole bunch of other analysts that weren't in any of the paperwork that I had been given. And the original testing had apparently been done up in Virginia, and they were only going to fly in one person from Virginia to talk about that testing, and it turned out they had 11 other analysts that were a part of the testing, none of whom I'd been given notice of, right? And so we go through this hearing, right? And the state's starting to think, oh my God, I'm going to actually have to prove up this DNA with these 11 other witnesses. And the judge is freaking out because if he's going to let these 11 experts come down and testify that I've not received any notice of, even though I've requested notice of the experts, then we're going to have to postpone this trial for several weeks. And the judge ultimately let in all the DNA just the way the state wanted, right? But my view is that if we had lost this case, as frankly I expected to do at the outset, we would have had something pretty meaningful to talk about on appeal. So, just again, these motions, even though they may seem sort of frivolous, they can amount to something. So be careful. All right. So this next case is about what the police didn't do, and this was a guy who basically went to the bus stop. He was holding a bag. The police thought he was suspicious. They had the bus stop, so they say, just sort of randomly under surveillance. There was like 8 cops, I guess, just hanging out. And so one of the cops walks up to my guy and starts talking to him, and my guy kind of hemmed and hawed when they asked to search his bag, but ultimately he said, sure, go ahead. And inside there was a couple kilos of cocaine and a half a kilo of codeine and several pounds of marijuana. And so, the bad was that, he had a pharmacy inside of his little bag that he's got right on his shoulder. And he gave consent. And even he basically acknowledged that he gave the consent, that at some point he said, you can search. The good was that the police really didn't do any other investigation, and the defendant had something to say. His story was basically, I knew I was carrying marijuana, but I didn't know I had the rest of this stuff, which, maybe that works, maybe that doesn't in every case, but he had something to say about it. And the way the consent was given was, I think, less than ideal. And when you're talking, and so this is about, what we're really talking about is, how do we get into everything the police didn't do here? How do we get into all of the different stuff that the police could have done, should have done, might have done, if they had really been interested in getting to the truth, if they'd really been interested in prosecuting this case properly? And for this, what I do when I'm trying to develop that is I plant my ass in front of the computer, because this was like a 1-page offense report, right? There was at most a page of pertinent material in the offense report. So you really have to kind of think, what else is going on that I'm not seeing on this page? And I sit there at the computer, and I'm not a touchy-feely person, but visualize your cross-examination. Sit there and type out every question and just envision it as the answer is coming. And I'm not saying that plan for the answer to be this way or for the answer to be that way. Just envision yourself asking these questions with the witness sitting there on the stand. And you will see and think about stuff that otherwise wouldn't occur to you, right? And I'm not saying that when you actually get to cross-examine this witness, you should rely on that script. I'm not suggesting that at all. What I'm suggesting is that you have thought it through that way, and that you have actually seen it from start to finish, all of the different garbage questions you'd want to ask and thought about asking and considered asking. And because one question that will come up will lead you to 3 more, and those will lead you to more. And I can't replicate, I can't get there and see all these questions unless I'm actually sitting there at a computer, typing them out as they go. And the cadence of typing these questions out actually tracks very closely to the sort of cadence of trial, where people talk more slowly and answers come more slowly. And like I say, once I've done all this, I come up with pages and pages of questions. I basically just circle them into groups, so it's subject matter. And I just make sure that when I'm sitting in trial, I have the various groups. Again, I'm not trying to suggest you script your cross. You need to be listening for what the witness is saying. But just having thought about it and just having seen it and understood it is a really helpful process. And particularly in a case like this, right? They didn't get written consent from my client. They didn't record the conversation of my client giving consent. Right? They didn't interview him afterwards. They didn't ever fingerprint or do DNA testing on any of the stuff that was in his bag. Right? They didn't do any of that stuff. And on the face of it, that doesn't sound like such a big deal, right? I mean, the guy's at the bus stop, he's got a shit ton of drugs. What else do they need to do? But unpack that and think that through. They've got 8 cops out there. How hard did they think about who was going to be there that day? How did they plan out who was going to be there and when they were going to be there? How did they plan out who was going to play what role out there at the bus stop? Who was going to walk up to the people? Who was going to be the follow-up person to walk up to the suspects? Who was going to be the person to search through the bags? How are they going to go about doing this, point by point by point? And if you do that, you start realizing they went through all of this planning. They did all of this preparation, and yet they still didn't bring an audio recorder. They knew the only way they were going to get in people's bags was by getting consent. But they specifically didn't want to make recordings of how they got this consent. They knew that in court, consent is litigated all the time. They knew that consent could be challenged, and they specifically chose not to make a recording. They specifically chose not to give my client a written form where he could give consent, right? And they specifically chose not to interview him afterwards to get something on video where he says, yeah, you know what, I agreed to let you go in the bag. When you start unpacking all that and you start really thinking through what was going through these officers' minds beforehand, how they're planning to go up to people at the bus stop randomly to get consent to get into their bags. And they are specifically making it so that the only way to verify the consent is through their word, right? And you see that that's been their plan all along, right? All of a sudden it starts to smell a little bit. And when I was thinking about it, I mean, it dawned on me off the top. There's no consent to search form. There's no video or audio recordings, right? But until I sat down at the computer and started thinking it through, where were these guys an hour before this happened? What were they thinking about earlier that morning? How did they make these plans to get there? What is all the details of the planning they went through and still didn't bring anything to record? All these 8 cops that are out there brought nothing to record any of these conversations, right? Any of these consent, approaches of suspects there. And so the pleadings and the appellate issues here, is interesting. The prosecutor, you think it's a drug case, right? What could there be about a pleading? The pleading is there's nothing to it. But the prosecutor made the argument that knowingly, as defined, just means that you're aware of the circumstances surrounding your conduct. Well, the defendant got up and testified, said, I thought I was carrying marijuana. I didn't know I had a whole bunch of cocaine. But the prosecutor said, well, all right. He still knew what the general circumstances were of his conduct. He knew he was carrying drugs. Right? Now that's not a correct understanding of the law. I objected to it, but the definition of knowingly, right, as it was a part of the pleading, made a big difference. What did he know? Did he know that there was cocaine? Did he not know that there was cocaine? Is it enough that he knew there was drugs? How much of these circumstances surrounding his conduct did he actually have to know? And frankly, I anticipated this argument from the prosecutor, but I did not anticipate that definition. The circumstances surrounding the conduct. I didn't look at the knowing definition thinking that it might have meaning to the case. And that was a mistake on my part that could have come back to bite us. And as far as the legal issues, of course, there was the motion to suppress that we filed with the court all along, and if we had lost, then it would have gone up on appeal as a motion to suppress. But there was also the consent issue as it was built into the jury charge. And in this particular case, the charge bank was wrong and said that the jury only had to be convinced by clear and convincing evidence that the consent was valid. And that was an error in the charge bank, and I was glad that I had looked that through and researched that a little more closely, because I think that made a difference. Okay, last case, and this is a case where what the state witnesses did, a lot of it was really helpful. And this was actually, some of you may have been aware of this. This was in the media a little bit. There was a husband and wife who they had a little boy that had gotten out of the house, and he was pretty hyperactive. He went out and he was in front of their house and he got hit by a car, and it drew a CPS investigation. And with CPS investigating them, a month later, this kid found himself with handcuffs around his ankles. And the parents decided that they didn't want to call the authorities to get these handcuffs off, and they couldn't find the key to get these handcuffs off. So they got the bright idea to use a mitering saw and cut these handcuffs off of their 3-year-old. And they did this for, according to my client, about 14 hours. And it burned the kid's legs terribly. The pictures were, it was really shocking, is the right word. And so the bad, right, is obviously you've got these horrible looking pictures, right? I mean, and it's like this 3-year-old he's got like this smile on his face at the hospital, like he's just so relieved to be away from his monster parents. And this car accident, right? He's a hyperactive kid. Why are the handcuffs on his legs? Well, surely it's because the parents put them on there so he couldn't get back out into the street. And this idea that they would try for hours on end to cut these handcuffs off is just, it's a really horrifying vision. But the good was that it turned out this kid's injuries healed very nicely on their own. He has scarring, but